Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride.
Hello, 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 hello. This feels safer. Come into my kitchen, William. Let's have a coffee and watch some court. A good day to me. I hope everybody's doing well today. If you were just at the premiere, thanks for going. Appreciate that. My cat burglar outfit. No, this is my I'm working today. I've been working all day outfit and just like not doing my hair. Have barely any makeup on. Getting stuff done. It's also cold, so I like to have the hoodie on as well as the hat. I guess that does make me look like a 2000s era thug. Oh, what can I say? Guilty. Anyways, like I said, I hope that everybody had a good time over at the premiere. We are on a bit early tonight because tonight Mikey is over on Tech Troublemaker at 6 o'clock, that 6 o'clock slot. And I also have plans. So works out perfect for me to do an early one tonight. I've already set this stream up to redirect to that in case you want to check it out. But even if you don't, go over there and hit the like, because it's very helpful and encouraging to us YouTubers when we get likes and the like. So without further ado, we have some court to watch. Like I said, I was working today, but I was working on multiple different things. So I'm realizing that I am missing one. Hold on. Oh, no, I'm not. Never mind. No, I'm not. No, I'm not. Never mind. Yeah, dress up like Eminem. I don't know. This is my like working outfit, I guess. Because I'm the real Slim Shady. That's why. Bromlick's court looks so much like. Hold on, I gotta scrub this so I can see how long it is. Short. Okay, not what I want. This one. This is the one. Okay. If I take off my hat now, it'll be so bad. Oh, my gray hairs is terrible. Absolutely terrible. Also, I haven't watched any of these yet, so viewer discretion is advised. Come on, Judge. I want to know if that is a crystal around Sabrina's neck or if it's a penis. Oh, confirmed penis. She covered it up.
Court is now in session. Page 1, Sabrina Castro versus Jesse Castro.
For the record, this matter is before the court on the plaintiff mother's motion to modify custody. This hearing is being conducted via Zoom. It appears that both parties are present. Plaintiff mother Sabrina Castro and defendant father Jesse Castro. Good morning.
Good morning.
Good morning.
Hi, Grammy.
The two of you have conferred with Mr. Walker from the front of the court this morning, who has provided the court the following recommendation. At parenting time shall be as follows. The party shall parenting time week on, week off with exchanges on Sundays at noon. Further, the parties shall share holidays as agreed upon. Of course, I will let you know, even though this recommendation does not state that, if you cannot agree upon holidays, the fallback is the Monroe County Friend of the Court holiday schedule. You can get that online. Recommendation. Ms. Castro, do you understand the recommendation?
Yes.
And of course, the two of you can share joint legal custody, which means you share equally any major decision concerning the welfare of your two children.
Yes.
Ms. Castro, do you have any objection to the court adopting this recommendation?
No, sir.
All right, Mr. Castro, same question to you. Do you understand the recommendation, and do you have any objection to the court adopting the recommendation?
No, I do not. And absolutely,
Right.
I do understand.
All right. All right, can you both raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
I swear.
Thank you. Ms. Castro, please state your name for the record.
Sabrina Castro.
Ms.
Can you hear
Castro,
me?
do you believe this? Yes.
Oh,
Do you believe
sorry.
believe this recommendation is in the best interest of your two children?
Yes, sir.
Okay. Thank you. Do you have any questions?
No, sir.
Right, Mr. Castro, same question.
I was wondering how long she was going to put her hand up for. It's almost like she did an Uno reverse. Because when I went to school, when you had a question, you raised your hand. And when you didn't have a question, you didn't raise your hand. But she was doing the opposite. She just kept her hand up. Drunk Beaver Productions. What's up? What's up? I'll even forgive misspelling favorite. Anyways, like I said, I don't know what's going on with these two. I guess they're doing an agreed upon thing, but you know what? We've seen it start agreed upon and then fuck up. Oh, William, that's funny. Oh, shit.
Do you believe this a recommendation in the best interest of your two children?
Yes, sir, I do.
All right. The court finds agreement between the best interest of the two minor children. The court will call the adopt agreement. And also, the court's going to conduct a pre-trial conference at this point in time and schedule this matter for mediation. Mr. Walker, I don't know if you have, I don't have my mediation schedule in front of me. The two of you have been separated since March of 2021. Is that correct?
That is correct, sir.
Is there any chance of reconciliation?
No, sir.
No.
All right, so let's get this matter moving. Typically, what the court would do is schedule this matter for mediation with front of the court, like Mr. Walker is a certified mediator or someone else from his office to work through any issues. So I'd like to identify what are the issues. Obviously, you've agreed upon custody and parenting time. Is there real estate to be divided?
No, sir.
Personal property?
No, sir.
You've been separated for almost, 3 years?
Yes, sir.
So what has prevented you from getting divorced?
Waiting for the court date.
Okay, well, you got a court date today.
Can we get divorced today?
Well, you need to, Ms. Castro, you went online and you printed out a form of complaints, correct?
Yes, sir.
So you need to go online to get what's called a judgment of divorce with children.
I have that, sir. I just have to get it turned in.
Okay, so you need to complete that. For example, it says, joint legal custody, week on, week off parenting time, exchanges on Sundays at noon. The other thing you need to agree upon is child support. Mr. Walker can provide you with a recommendation because you need to also attach to your judgment of divorce what's called the Uniform Child Support Order, in which you address child support. Unless you're going to agree that child support be reserved, then each will support the child while in their respective possession. But that can be difficult because obviously you have issues like school clothing, if they're in sports, athletic items. So the one thing you need to probably do is we need to address child support judgment divorce. But the other thing is there are no joint debts, correct? So if you look at the judgment divorce, it's basically fill it in the blocks. No real estate, no joint debts, retirement. You've been married 3 years, so each of you will keep your own retirement benefits, free and clear of any claimant part of the other. Each keep their own automobiles, paying debts in their own names. Spousal support is not appropriate. That's alimony because this is a short-term marriage. So there's a block that says spousal support is not awarded. It's forever barred. So you can pretty much fill out that judgment. The court could take some brief testimony this morning, and it means you don't have to come back to court. It's simply you need to both fill out the judgment. Both you need to sign it and date it on the second page. So two of you should get together, and obviously it's one for the year on terms. So what about child support? Do you want to talk with Mr. Walker, get a recommendation regarding child support? You can, based upon your...
This judge sounds like an auctioneer trying to sell them something. Listen, it sounds like you've got everything you need. You've got everything you need. We both have everything we want. Let's talk about getting you divorced today, folks. I can get you into the best divorce you have ever even dreamed of with the filling out of just a few tiny papers. All you have to do is say that you're not pregnant, that you don't want to be with him anymore. Bingo, bango, you're divorced. I don't know why it devolved into some New York thing. Hi, thank you for visiting, by the way. Most courts that I see love paperwork, though. They love to take their time.
Your 1099s or W-2s from last year, you can probably give you a verbal recommendation. Of course, child support is always up to modification. You can always change it. You can go up or down as the needs of the children increase, as your respective incomes increase or decrease.
Absolutely. And so I don't know about Mr. Castro. I, however, am good with foregoing it, at least definitely for now. Neither one of us have been giving support to the other thus far, and we've been doing good as far as I'm concerned. I don't know Mr. Castro's exact situation, but I'm good with foregoing that now.
Okay, so in judgment of divorce, there's a paragraph regarding child support. Just put in there where the word reserved, which means that either side can petition the court at a later point in time. You can't order that they're not being child support, but you can put the word reserved in there, and that will address that issue.
Okay.
The other issue that needs to be addressed is, Ms. Castro, do you still receive public assistance?
I do.
Okay. Mr. Castro, do you receive public assistance?
I do.
Mr. Castro, do you receive public assistance?
Yes, I do.
Yeah, he heard you. He just wanted you to say it twice. That's my theory on that. And no worries at all, my friend. We are just hanging out, chilling like villains.
Well, okay, the reason I'm asking is because there's a $255 filing fee. And that should not, the taxpayer shouldn't have to pay this. You're both young, able-bodied. I don't see any disability. So that's got to be addressed in your judgment. I'm gonna make a note of that. And I don't know how it's paid to the Monroe County clerk. It's got to be paid in one lump sum. They won't accept installment payments. But the court's gonna, when the court receives a judgment, the court's gonna add some language in there. So I want to discuss with you your agreement relative to who's gonna pay that $255, unless you both agree to share that equally.
I'm okay with that.
I'm good with
If-
that as well.
Again, I don't know who's got the greater income.
That I'm not sure. I work part-time at Taco Bell.
Okay.
Part-time at Taco Bell, but that still means, I mean, she probably gets food, right? We don't have Taco Bell where I live. It makes me sad. Yesterday I was bitching about groceries. Still have not got groceries. But I want to make quesadillas, my own version.
So that's, I mean, each you pay $127.50. So you make a note, there's a filing fee of $255 paid to Monroe County clerk. Will not take a half payment from Ms. Castro and half payment from Mr. So who's going to pay it? Mr. Castro, will you pay that?
Yes, I will. Yes, sir.
Okay, so you can put in the judgment, if you miss it, of course, you can put that in there, that Mr. Castro shall pay the $255 filing fee to Monroe County clerk, and Ms. Castro will reimburse him 1/2. So Mr. Castro, we need to set a date. For example, can you pay that by, how much time do you need to pay that? Do you need to the end of May to pay that? End of April? I mean, end of April.
At the end of May, if that'd be okay, I would do the end of May. I could have it paid by then.
Okay, so put in the judgment that you should pay $255 filing fee to Monroe County clerk on before May 31st, 2024. And Mr. Castro, if you need additional time, you call the court and I will give you an additional time. Just don't blow it off. You blow it off, that's when bench warrants issue.
Oh yeah, absolutely, sir. I will be taken care of.
All right, so the court would put in the judgment. There's usually toward the bottom before your signature, before the signature for the judge, there's a spot there and says other provisions. You can write in the language, and the language should say defendant Jesse shall pay $255 filing fee to Monroe County clerk on before May 31st, 2024. Plaintiff Sabrina will reimburse him for 1/2. And
Okay.
all right, so the court's going to take some brief testimony this morning. That there's a breakdown. It's a required testimony that you don't need to come back to court. It's just a matter of submitting that judgment. When you submit that judgment, then you'll be divorced. And Ms. Castro, there's another provision if you want your former name restored, or you're going to keep the name Castro for the benefit of the children.
I was thinking about it. Mr. Walker did let me know that I can check it and then decide later. So I think I will do that.
Okay, so you fill in the blank about your former name restored, put that in there, and it will not occur until you take that judgment to the Secretary of State and Social Security. So in other words, if you decide not to change it, then you just don't you don't provide Secretary of State and Social Security with a copy of that judgment of divorce. But at least the mechanism is in the judgment to do that if you choose to do so in the future, okay?
Absolutely.
Well, it's wonderful. The two of you can obviously still be friends. For the benefit of your children will thrive when you're on the same page. And there will be challenges in the future without question as they grow up, but you need to be on the same page for their benefit. So wonderful. So anyway, can you both please raise your right hand to be sworn? Again, I'm sorry, you've already been sworn. You both confirmed that this recommendation regarding training time is the best interest of children. So Ms. Castro, just for the record, please state your name and current mailing address.
Sabrina Castro, 1500.
Thank you. Ms. Castro, is it true that you filed a complaint for divorce with this court on about February 27th, 2024?
Yes.
Is it further true that on the date you filed that complaint that you'd reside in the state of Michigan at least 6 months and County Monroe at least 10 days?
Yes.
Was it further true that you married Jesse Castro on July 25, 2018? You separated in March of 2021?
Yes.
Is it true there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed? There's no reasonable chance of reconciliation.
Yes.
Is it true there were 2 children born of the marriage who are still minors?
She creed framed. It's her. She creed framed. Since this is a divorce, please raise your right hand and swear at each other. That's funny, Bill. Hi, wahoo. Let's see how long it takes for her creed frame to end.
It looks like Ms. Castro froze up.
Yep, I did. I'm sorry. I'm back.
Ms. Castro, is it true there are 2 children born of the marriage who are still minors?
Yes.
Are you currently pregnant?
No.
Do you have any questions for the court?
No. The only thing is, so after this, I will get the judgment for divorce, get together with Mr. Castro, fill it out, and turn it in by May 31st. With that filing fee, right?
Well, you can turn it anytime. You can turn in,
Okay.
in the next couple weeks. You can bring it up to Judge Brock's court, or you can put, there's a Dropbox outside the court if you want to drop it off on Saturday or Sunday. Just put an envelope with Judge Brock's name on it. Or if you're
Okay.
bringing
There's a
down,
divorce Dropbox, folks. Did you know that, by the way? Also, if you are like, holy fuck, this lady pauses this video so much and talks so much, I have news for you. These are lives. I am alive still. And while I am, I will continue to talk. But that's why I made the video earlier for you guys. And maybe if I'm still feeling it, I'll do it later. You know, make this into a video. Probably not. But tagine, I think, isn't that a cooking type of vessel? Or is that a tagine? Tagine. And you're not talking about tahini, right? A reaction commentary channel. I know. I just feel the need to say it because every night, sometimes I go to bed and I wake up in the morning and there'll be a bunch of comments from my last live. And I'll know that that means that the live's gotten some traction because people are like, oh my God, would she shut up? Maybe you should try talking less. Your channel would grow faster. And I'm like, I know, but I don't really want my channel without me. I already make videos. Oh, tahini is the spice mix. Yes. Oh, that's like the, it's Mexican, right? Is it? Maybe that's racist. I didn't mean to be racist. Also, if you notice, it's jittery when I'm on the screen, so that's why I'm dipping off the screen.
the courthouse, if you want to shorten things, you can just drop it off at Judge Brock's office. The court will sign it, then each of you will be mailed a copy. So you don't need to wait till May 31st to do that, but there needs to be an added, you need to write in the judgment about the payment of the fine fee by May 31st.
Okay.
So that can be, the judgment can be entered before then. All right, Mr. Castro, can you please state your name and current mailing address for the record?
Jesse Castro, 436 Invergary Street, Temperance, Michigan, 48182.
Thank you. Mr. Castro, did you hear the testimony this morning of your wife, Sabrina?
Yes.
Was her testimony true and accurate to the best of your knowledge?
Yes.
Do you have any questions for the court?
No, I do not, sir.
All right. Again, it's wonderful the two of you are on the same page. Based upon the testimony that's been presented this morning, as well as the complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that marriage can be preserved. Accordingly, upon receipt of the written consent judgment of divorce approved by both parties, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved, and judgment shall enter granting a divorce and bonds of matrimony. Well, good luck to both of you. No need to come back to court. Just print out that judgment of divorce. If you cannot find it online, you can always come down to Judge Brock's courtroom and we can print one out for you, Ms. Castro.
Okay.
All right, good luck to both of you, and we'll wait to receive that judgment, and the court will sign it. No need to come back to court. Well, good luck to both of you.
Thank you,
Good
sir.
luck. Thank you so much.
Welcome. You can zoom out. Have a good rest of the day.
You as well.
You as well.
Bye.
Zooming out is obviously one of the funniest terms that people use. I also really like it when Judge Simpson says, or as your Zoom-vite indicates. Okay, on to the next. On to the next, she said. On to the next. Oh, tacos. I want taco. And when I say tacos, I really mean a quesadilla. Right, Bill? You're at home here. Okay. Let's see what else Bromlick had for us. Also, I actually want to point something out. I just recently did a little visual scan, with my eyes of my of my videos, and I was looking for like patterns, and I recognized something without meaning to, just because of how many judges I include on the front of my videos. I have so many thumbnails that include a United States flag, like amazingly high numbers for me. It seems so weird. I realized, I was like, oh my God, look at all the American. Oh my God, there's an American flag in like almost every one of these, Paisley. Holy shit. See what the framing situation that we have on the wall here doesn't look good to me, but I don't know what looks good. But to me, there's like totally different colors, shapes, sizes, heights. I don't see the rhyme or the reason. I don't understand it. It's something I don't understand.
Now in session, there will be one. Mrs. Grant, please.
For the record, this matter is before the court on the plaintiff's motion for child support. This hearing is being conducted via Zoom. Present is Attorney Eric Chappell, representing the plaintiff petitioner Karen Newsom. Ms. Newsom appears to be present. Mr. Chappell, in addition, Attorney Matthew Viddo is present, representing the defendant Brent Newsom. Mr. Newsom appears to be present with Mr. Viddo. Good morning, everyone.
Morning, Your Honor.
There's also, and I don't know if this was discussed this morning, Mr. Chappell, Mr. Viddo did file a motion for to show cause, which is scheduled for hearing on, it was filed yesterday. The court entered an order yesterday scheduling that for hearing May 29th.
I think we have a global resolution, Your Honor.
Okay, wonderful. I was just hoping that could be discussed. If not, the parties could mediate the issue. In any event, the parties have conferred with Ms. Patrick from front of the court. Ms. Patrick has provided the fine recommendation. The court recognizes a 16-year-old child. That with respect to child support, commencing March 1st, 2024, a defendant, father shall pay child support in the amount of $800 per month.
$800 per month is the negotiated amount for one child. Wow. Wow. Look at both of these lawyers barely containing themselves. Barely containing themselves after charging both of these people God knows how much.
Uninsured medical expenses shall be shared as follows. Plaintiff mother paying 39%, defendant father paying 62%. This is based upon defendant father having 75 overnights per year. It's further recommended that the defendant's motion for show cause be withdrawn. And of course, with that, the hearing of May 29th at 1:30 will be vacated. With respect to parenting time, defendant father shall have 1 weekend a month by agreement or such other times as parties can agree. A father shall have summer parenting time of 2 non-consecutive weeks during June, July with 30 days advance written notice to plaintiff mother. Party shall continue to use their friend of the court holiday schedule, and party shall share transportation apparently as they have in the past. That's the recommendation. Mr. Chappell, is this recommendation agreeable with your client this morning?
It is, Your Honor. Just as you recited it, I would just want to add that the summer parenting time is also by agreement. The intent, and with me saying that, Your Honor, is to just make sure that it works with the daughter's schedule and everyone. And obviously the time will occur, but they will do that by agreement as they do the 1 weekend a month.
And
But
I did
otherwise,
omit.
otherwise everything is as we agreed.
Thank you, Mr. Chappell. In fact, Mr. Patrick does have the word by agreement in there. I just didn't say the word agreement, but it does say 2 non-consecutive weeks during June, July with 30 days notice by agreement to the plaintiff mother. So that is noted as part of this written recommendation, recommended order. You're welcome. Mr. Vido, does your client have any objection to this recommendation?
Well, there's one correction I think needs to be made because my recollection was it was 1 weekend per month and any additional time by agreement, not or should not be 1 weekend a month or any other time agreeable by the parties. It should be and any additional time agreeable by the parties. So it's a minimum of 1 weekend a month and any additional time agreeable by the parties.
Correct.
And Ms. Pat, perhaps you could modify this and indicate the defense file shall have 1 weekend a month by agreement and any other times parties can agree. We'll just change, we'll delete the word or for and. Is that what you're suggesting, Mr. Vido?
Yeah, I don't have the written phrase in front of me, but if it's phrasing it the way that you have, I think that's accurate.
Yes, it's the way it's written is defendant father shall have 1 weekend a month by agreement or other times is agreed. You want the or to be replaced by the word and.
Correct. Thank you.
Right.
I've done
I think
that.
everything else was acceptable and accurate.
Thank you. Any objection, Mr. Chappell?
None, Your Honor. That was the intent.
Okay. All right. So Ms. Patrick, we just eliminate the word or and replace it with the word and.
Yes, Your Honor.
Clarify that. All right, Mr. Newsom. Looks like Ms. Newsom is now, her last name is Godin. Can you both raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes. Louder.
Yes. Yes.
Like Mr. Newsom? Mr. Newsom, you need to speak up. We can't hear you from back there.
I said yes.
Thank you. Thank you. All right, Mr. Chappell, we're going to just briefly order your client, please.
I will. Can you state your full name for the record, please?
Karen Elizabeth Godin.
All right. And you had the opportunity to participate in the front of the court meeting that we had this morning. There were negotiations back and forth, correct?
Yes.
Okay. Is it your decision to enter into this agreement today?
Yes.
You understand that if you would have the ability to have a hearing where the court would determine incomes and you might receive a higher number in child support. But do you believe that this is in the best interest of your daughter?
I do.
Okay, and you're comfortable, you feel this is a fair resolution of all the issues that have been raised by yourself and Mr. Newsom?
I do.
Okay, all your questions have been answered?
Yes.
Happy with my representation?
Yes.
Okay, thank you.
Thank you, Mr. Chappell. Mr. Vido, do you have any questions, first of all, for the plaintiff mother?
No, I don't. Thank you.
Any questions for Mr. Newsom, please?
Yes, Mr. Newsom, remember to speak up, but you've heard the agreement that's been placed on the record.
Yes.
You're asking the court to adopt this agreement.
Yes.
Okay, and you understand that had we gone to a contested hearing in this matter or a trial, we could have reached a much different result.
Yes,
It could have been better or worse?
yes, correct.
Or even the same?
Yes,
But you want the court to adopt this one?
yes, that's correct.
Do you believe that this agreement is in the best interests of your minor daughter?
Yes,
Okay, and do you believe that the outcome is fair, all things considered?
yes,
Okay. And in the capacity of the resolution session that we were in, you were able to go back and forth and negotiate this outcome.
yes, that's correct.
Okay. Are you satisfied with my representation?
Yes.
Okay, thank you. No further questions.
Thank you, Mr. Vito. Mr. Chappell, do you have any questions of Mr. Newsom?
I do not. Thank you, Your Honor.
Lastly, and of course, the court's aware by Mr. Vito's motion that plaintiff mother and minor child live about 3 hours away from dad. They're both on the same page relative to transportation, correct? I don't know if they're meeting halfway or.
Yep. Yes, Your Honor, they've had a system in place that we are going to keep in place.
Wonderful.
Yep.
All right, so with that, the court finds agreement between the best interest of minor child. The court will adopt agreement. Court would like to thank Ms. Patrick for assistance, as well as, of course, Mr. Attorneys Vito and Chappell for helping facilitate ample resolution of this matter. The minor child's going to be an adult before we know it. All right, that will conclude this hearing. Thank you all. You can zoom out. Have a good rest of the day.
Thank you, Your Honor. Have a good day.
Thank you.
And the hearing of May 29th is vacated, Mr. Vito.
Yes.
Thank you, Your Honor.
Thank you.
Okay, onward we go. We have just a hodgepodge of court tonight.
Hello.
Hello.
Yes, sir, I can hear you.
Okay, one moment, please. I'll call us into session. The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. It is Monday, April 22nd, 2024 at 1:18 p.m. for 2024 9 CB, the Yatuma Law Firm versus Tanya Robin and the other defendants, Attorney Hilderly for plaintiff and Attorney King for defendants.
Okay, good afternoon, gentlemen.
Good afternoon.
This is the time and place set for a status conference in this matter, so I'll go to Mr. Hilderly first and bring me up to speed. What's happening in the case or what isn't happening?
Should I get on top of it? No, you're good. Well, Your Honor, this is a fairly regarding attorney fees. The parties have engaged in some discussions in attempts to resolve the matter. We haven't gotten there yet.
Thank you.
So really, that's where we're at. It's not a complicated case, and we have been trying to work it out.
Okay. Have you, I'll just check, have you come up with or agreed upon a mediator and set a date for that, or what's happening in that regard?
We have not agreed upon a mediator yet or set a date.
Okay, Mr. King, what's your position?
Well, I'm not sure that I have a position at this time. There is
I am not of the pineapple persuasion, so I don't know my positions, Judge.
very good chance I'll be withdrawing either sometime this week. I don't believe my client has the money to pay me, and as much as I like them, I just can't do it for free. However, if for some reason they were able to come up with the money today, this is their deadline, then I would be interested in mediation. If plaintiff's counsel wanted to do that, that would be fine with me.
Okay. Well, I'll leave it up to you, Mr. Hilderly, as again, depending on what's going to happen with Mr. King and whether he withdraws or doesn't withdraw, the matter, court will want the matter to go to mediation. So you might want to come up with a mediator that you'd recommend. And if you can't get Mr. King to agree, maybe you can get the defendant to agree or defendants to agree as to a mediator so we can get that matter moving forward.
Okay, Your Honor, I will await Mr. King's decision on what he's going to do, and then either contact him or the defendants to try to set up mediation.
Okay, thank you. Mr. King, notify Mr. Hilderly if you are in fact withdrawing, and then he can proceed on what he needs to do with regard to mediation.
Okay, and then if I stay involved and we agree to a mediator, should we just let the court know?
Yes,
Call the clerk?
let us know right away, because if we don't hear from like you within, let's say, 2 weeks, then we'll send it to the mediation clerk and they'll randomly assign a mediator, and it may not be someone that you would prefer to have, so.
Fair enough. Okay, thank you very much.
Okay, thank you. I'll let you go. Have a good afternoon.
Thank you, Your Honor. I appreciate it.
All right, thank you. Thank you very much there. So let's move on to our next case here. Please unmute both of you.
Okay.
Can you hear me, Mr. Scroy?
I can, Your Honor.
Okay. All right.
That is an unruly last name. Scroy. SGROI. Scroy. Just rolls off your tongue like a boulder, doesn't it?
So now this is case 2024-745 CB. Your second salon and spa Inc. versus New Tech Small Business. It is Monday, April 22nd, 2024 at 1:23 p.m. Attorney Applebaum for plaintiff and attorneys Groy for defendant.
Good afternoon, gentlemen.
Good afternoon.
I'll go to Mr. Applebaum first. Mr. Applebaum, this is the time and place after the status conference. Bring the court up to speed. What's happening in the case or not happening?
Sure. The court, previously the plaintiff filed a motion for an injunction to toll the redemption period. This case arises from a sheriff's sale. The court, in the court's ruling, the court extended the redemption period 30 days, and the defendants would have to provide some sort of an accounting as to the amounts that were paid out, distribution related to the loan. The defendant did timely provide that, and the court indicated in the motion, in the ruling, that if there are further discrepancies, that the plaintiff could renew the motion. We did find that there were further discrepancies, so we renewed the motion for an injunction. That's scheduled to be heard on May 6th. With the plaintiff provided the expert disclosure pursuant to the.
Is he appearing from behind plexiglass? Like, what is going on with this line down the center here? I don't understand. Right? Oh man, I can't stop seeing this up.
Court's scheduling order. I know that defendant has some time to file theirs. So that initial disclosures were also submitted. I don't recall if I received initial disclosures yet from the defendants, but I'm not sure if they're due yet. I have to check the dates on that. And that is the status. So we should be back here in the next couple of weeks.
Okay. Mr. Sagari, what's your thoughts?
Well, I have several, Your Honor.
Okay.
I know the timing may have been off. The only way I knew about the status conference was because I looked the court's docket up.
Okay, the guy on the bottom is giving the most awkward court appearance we've seen in a while from a lawyer. You guys, he looks like, remember I used to tell that story? I made up a fictional story about how Judge Dismissal Dan got his job, and he was impersonating a lawyer and he went in to do it as a prank, but it worked. I'm getting vibes like that. He's like, okay, you said the thing you had to say. Okay, it's his turn. And he literally bowed his head to the fucking desk. Like, what is going on here? I'm going to roll it back just 30 seconds. And just look at his eyes right here. Like, and yeah, how is his tie tied? That shirt is so weird. We have some problems, folks. Look at the look. Oh, fucking shit.
That is the status. So we should be back here in the next couple of weeks.
Okay. Mr. Sagari, what's your thoughts?
Well, I have several, Your Honor.
Okay.
I know the timing may have been off. The only way I knew about the status conference was because I looked the court's docket up to see if something was coming up. I never received notice of the status conference. In addition, I have no knowledge of this motion that's been renewed that's up for May 6th. So there's something falling through the cracks somewhere. I'm not sure where, but.
Well, we will check our file to see why you would not have gotten notice, but as to the plaintiff, I have no idea, and I can't speak to that.
Oh, if I could just add, I mailed it last week. It just may not have come in the mail yet, to be honest.
That is the excuse we hear from fucking criminals all the time. Oh, I mailed it. No. I mailed it. I just sent him regular mail. What is going on here? Look at that freeze frame.
Speak to that.
Oh, if I could just add, I mailed it last week. It just may not have come in the mail yet, to be honest. If you haven't gotten it, I can email you a copy as well. But it was mailed last week, but the mailing can be slow sometimes. I don't know.
Okay. I don't know why you wouldn't have received it from us. We usually send it out well enough time to get that.
Right, and that's not a problem.
Yeah, when the case was filed initially, and we don't have a return of service yet, we have everything sent to the plaintiff's counsel, and then that attorney has to get a copy of the initial paperwork to the other parties.
That may have been the glitch at this point, is that apparently before there's a defendant represented or served, then we send everything to the plaintiff's attorney and they're supposed to forward it on, and maybe that didn't happen. So, well, in any event, we're here today, and so I guess at this point we're going to await that May 6th date when we have to address that motion. And I guess the only thing I would ask is that maybe the two of you converse, and if it goes further, that you come up with a name of a mediator that you might want to use in this matter, and maybe get a mediation date set up, because again, what happens if we don't have that, then our mediation clerk will just randomly assign a mediator, and it may not be someone that you want to mediate the case. So this way you have some input as to who the mediator will be, and the timing of the mediation as well, if you think it's necessary or would be productive, let's say.
I understand. I'm not sure if there's a whole lot to mediate and or facilitate, but.
Well, and that was my thought too. I didn't know. I'll leave it up to the two of you. If not, we'll address what we can on the 6th, and if that takes care of it, fine. If it doesn't, then we can talk about maybe mediating at that time.
Okay.
Okay. Okay. Well, we'll let you go today then, and see you back on May 6th, and we can proceed then.
Okay. Thank you.
Thank you. Have a good day.
Thank
You too.
Bye.
All right, perfect. So let's go on to last point day. So Mr. Battenberg is actually filling in for plaintiff. It's Attorney Mueller Wilson. All right, thank you for your patience, Mr. Battenberg. So now this is case 2024-808 CB, Hyphen Steel Products versus Marshall Metal Products. It is Monday, April 22nd, 2024 at 1:28 p.m. Attorney Battenberg filling in for Attorney Mueller Wilson for plaintiff. I do not have defendant here.
Are you like Tom Brady here? I heard that you had retired and now seeing you back, I don't know, how many times are you going to retire before you're actually gone?
Well, I've only been retired for a month and a half. My wife kind of asked the same question, actually, Your Honor, about that. And I think she would like me to unretire.
Ah, okay. Okay. Well, I was just surprised to see you is all.
Well, I'm helping out when I can. This is actually a case that I have some familiarity with. Although Barbara signed the pleadings, I handled the case up until the moment the lawsuit was filed. And then she had a conflict today. She's in another court, and she asked if I could step in and do the Zoom call with you, and I said absolutely.
Okay. Well, tell me what's happening. We saw that you did have service back on April 2nd.
That's correct.
So have you?
I can tell you what.
You just have a couple day or so before you get.
Yeah, tomorrow is the last day to file an answer. We have the only thing I can tell you that we've heard, and we have attempted directly to contact. I'm trying to remember the resident Ron Holcomb, the resident agent, about 3 weeks ago, just before the lawsuit was served. He made a partial payment of $2,000 directly to our client, and we told our client to do a couple things. One, tell him to send the money to us from now on, and two, if you hear anything further from him, let us know. We were going to try to contact Mr. Holcomb directly, and we did. The secretary at our office has attempted contact, but has not heard back from him or anybody there. So at the moment, I don't really think it's going to be a disputed case. It's just a matter of how we're going to collect it. I know that they're in business, that they continue to operate, and it's just a matter of how it's going to get paid. So right now, I guess we're waiting for the deadline to expire on the answering of a complaint. We've heard nothing directly from Marshall Metal Products or anybody who might represent them. Obviously, if we do, we will deal with it at that point. But if we don't hear anything, we would ask that the court allow us to submit a default judgment for entry.
That would be fine if you don't hear anything. If you do get an answer, the only thing I would ask at this point is maybe you attempt to arrive at and agree upon maybe a mediator that could hear the matter, and that way we would expedite it. We wouldn't lose some time.
Hold on. Oh, that's no. God damn it. Jumping the gun.
I mean, to get you back in for another status, then only at that point tell the same thing as, oh, let's get a mediator involved, et cetera. So.
Yeah, that makes sense. We would certainly do it that way if we can't work things out directly ourselves. And I think we probably would. I think our client is pretty realistic about trying to get paid and would entertain a payment plan as long as it's realistic and is a sufficient amount.
Well, keep us posted so we know what's happening. If obviously they don't respond and you do a default, then we don't need to obviously be concerned with mediation. But if they do answer, you'll want to maybe contact them and again try to come up with some agreement as to, again, as you say, the payment plan, or alternatively, if there is a dispute, then maybe get them to agree upon a mediator so we can get a mediator set up and try to expedite moving the matter along.
Very good. We'll keep you posted, Your Honor. If we don't hear anything from the defendant, we'll submit a default judgment. And obviously, if there's some sort of agreement, even a post-judgment agreement of some sort that is reduced to a writing that gets filed with the court, we'll let you know that as well.
Okay. Thank you. Good to see you again, and you have a good day.
Thank you. Same to you, Your Honor. Take care.
All right.
All right, on to the next. Hi, MB, by the way. If you guys are just getting here, thanks for being here. Make sure you hit the like button. It's a great way to help out. Now to you, judge lady.
Let's see, Jackie. So
we have somebody appearing from a peephole, it appears, on the top right of the screen. And we have a serious frown here from Adrian. Look at her face. Actually, everybody's a bit frowny on this call right now. It's a bit of a frown town. It's frown town. Seriously, look at them all. Nobody's very happy.
she's in the courtroom. Mr. Sobolski, if you can start your video and unmute your device. Thank you. All right, this is in the matter of Jacqueline Sobolski versus Barry Sobolski, file number 2019-46484DM. I have Adrian Iddings appearing on behalf of the defendant. Miss Iddings, we are here on a friend of the court show cause. This has been adjourned from April 8th. I know that Mr. Raines is on the other side. And they have not yet zoomed in. We were last here, your client entered a plea of not guilty, and we adjourned it to today to give him an opportunity to meet with you, Miss Iddings. We are receiving payments through Good Life Tattoo. We are not receiving the full monthly obligation. And he also has an order from January 2024 that he's supposed to pay a minimum of $50 a month towards the arrearage. So, Miss Iddings, and the monthly amount is $775. So I don't know if he needs to have an income review or so. Ms. Iddings, how would you like to proceed?
Thank you, Your Honor. I had a chance to talk to Mr. Sobolski and go over the numbers with him. Certainly, he understands the severity of being that far in arrears. What I told him is that with a show cause, you're going to be looking to see if he has been failing to pay child support to the best of his ability. He was in an apprenticeship, and so he left one job, and I explained to him that if you leave one job voluntarily making a certain amount of money and take a job making less money, the court doesn't care that you're making less money. You need to make what your prior job was. He understands that. I told him with the amount of arrearage that he has, that if he needs to get a second job to start paying that down, he absolutely needs to do that. He told me they finally did do the income withholding order. And I also reminded him that he was supposed to pay an additional $50 a month. What I would ask, Your Honor, is if you would give him a chance, maybe a couple of months to try to pay that down. He is filing his taxes. He believes he's going to have a refund, and that will be hopefully captured by the friend of the court. So there'll at least be an amount paid down initially towards that very large arrearage. So that was my advice to him. I said, if you're looking at this case, he would be, he hasn't paid it to the best of his ability. He owes over $11,000. I just don't want to see him go to jail because they finally are taking some money out for him, and he finally is booking clients. He said for the first time since he started this new profession that he has clients booked out a month and two to come in. So I would ask, Your Honor, that you give him a couple of months to work on that, get those clients in and start making those payments, and to make sure his taxes are filed so they can capture that refund. So at least Mrs. Sobolski will at least get a lump sum of some portion, and then to come back and see where he's at.
So his arrearage now is $12,333.28. Mr. Sobolski, at some point, the Attorney General's office could charge you with a felony. So it's for your felony, and then they put you in jail until you can pay 20%, and it's a pretty miserable experience. So, Mr. Sobolski, if for some reason we don't capture your taxes, make sure you apply that money you get to your arrearage, and You know, Ms. Sittings is correct. You need to get a second part-time job. I think also, you know, Ms. Sittings would possibly review to see if you need to have an income review, but whatever it is. So I'm going to adjourn this to June 24 at 8 a.m. And Mr. Sobalski hopefully will have steady payments and payments on the arrearages. So thank you.
Thank you, Judge. I appreciate it. Barry, get working on that and I will touch base with you soon. Get those taxes filed, like immediately, okay?
All right.
Thank
Very
you. Thank you,
good.
Judge.
Thank you.
Thanks.
The matter of Jason Kuritz versus Nora Kuritz, that matter has been adjourned to June 24 at 8 a.m. In the matter of Andrea Hawken versus Eric Zay, file number 2014-40451DS, that matter has been adjourned to May 20th. All right, Mr. Zay, May
Thank you very
20th
much.
at 8 a.m. Thank
Thank
you.
you.
And the record will reflect Ms. Hawken was here in person, and Mr. Zay is zoomed in. All right.
Thank
In
you.
the matter, thank you. In the matter of Megan Marquis versus Christopher Schudel, file number 2018-45822DP. That matter has been dismissed. In the matter of David Shords versus Jessica Shords, file number 2020-47465. That matter has been adjourned to June 3rd. In the matter of
Which matter, Judge? Whoa, Andrew.
Are you Eric? Are you Andrew? Let me find you, Nelson.
Correct.
All right, this is in the matter of Kayla Bush versus Andrew Nelson, file number 2021-48816. Mr. Nelson, obviously we're receiving payments and everything's going well, so this is going to be dismissed, okay?
All right. Thank you.
All right, thank you. Keep up the good work.
Appreciate it. Bye-bye.
Thank you. Bye-bye. In the matter of Marquetta Martinez versus Abel Mendoza, file number 1998-20548DP. This is the date time set for show cause in this matter. Mr. Mendoza has an arrearage of $8,171.24. The last payment we received was $300 on February 9th of 24. This is arrearages only. Was he making steady payments monthly before that? February 9th date?
No, he has, excuse me, he hasn't made a payment since 7 of 2023 for that last payment for 300.
Okay, so issue a bench warrant for his arrest for failure to appear. I'll set bond in the amount of $500. All right, thank you, and let's see.
Lisa, I keep looking at both of their desks thinking, wow, they're super, super organized compared to whatever my desk is.
I don't have paperwork on this one. This is in the matter of Shani Tyndall versus William Jarrett Sager, file number 2000-22380 DP.
You don't have paperwork?
No.
Oh. He hasn't made a payment since August. He has an arrears of $9,471.35.
And we have paperwork showing he was served or
Yes.
sent paper. Okay.
Yes, we
And
do.
what's his monthly payment?
His monthly payment is $1,716.
Did somebody maybe put William Tyndall on the paperwork? Is
It
it
might have
file
been
number?
me, probably. 00?
Okay. Yeah. All right,
That'd be
never
me.
mind. So this is in the,
Sorry.
this is file number 2000-22380.
Oh, I
So, in this case, William Sager is supposed to pay $1,716 a month in child support. He has an arrearage of
$1,700 a month, did she just say? What? How many children? That seems like it's above the maximum.
$9,471 on the paperwork. Is it
It might
file
have been
number?
me, probably. 00?
Okay. Yeah. All right,
That'd be
never
me.
mind. So this is in
Sorry.
this is file number 2000-22380.
Oh, I
So, in this case, William Sager is supposed to pay $1,716 a month in child support. He has an arrearage of $9,471. Last payment was August 22nd of 2023. He's failed to appear. May issue a bench warrant. And I'm gonna set bond in the amount of $1,500. All right,
Sorry about that, Judge.
it's okay. I looked at the names, not the number. I think I got like a list. Mr. Lewis, can you hear me?
I can hear you.
Good. This is in the matter of Catherine Rink versus Michael Lewis II, file number 2009-34541 DP. Mr. Lewis is ordered to pay $151 a month in child support. As of today's date, he has an arrearage of $10,247.98.
Hello, you cut out.
Sir, she was just telling about how you have a payment amount of $150 a month. So the guy before you had 10 times your payments per month, and yet somehow you are in a higher arrears balance than he is. Do you know how long that would take you? Behind 10 grand is better, but behind 10 grand at 150 a month is terrible. That's terrible.
Okay, well, you're supposed to pay $151 a month and you have an arrearage in the amount of $10,247. The last payment we received was $151 on April 16th of 24. So, Mr. Lewis, you got to start paying down the arrearage too. You know that, right?
I fixed the problem.
You fixed the problem?
Yeah. Well,
What's the problem?
I got, instead of a credit card, I got a different account that has a routing number and everything. So it should come out every 15th and it should be $200. So then I'll be paying more than what's ordered and get those arrears down.
That's perfect. Okay. So, all right, what I'll do is I will set this out to May 20th to make sure that payment comes through. So
Okay.
May 20th, 8 a.m., all right?
Okay, every 15th, 200.
All right, perfect. So we'll be back on the 20th to make sure that happened. Thank you, Mr. Lewis.
Have a good day.
You too. Bye-bye. In the matter of Brandy Welch versus Butch Welch, file number two, are you Butch Welch? Why don't you come up to the podium? File number 2017-44791 DM. All right, just stand up at the podium. So Mr. Welch, we're here on a front of the court show cause. States here you're ordered to pay $336 a month in child support. And right now you have an arrears of $1,904.79, so not huge. The last payment we show we received was November 8th of 2023 in the amount of $169.89. So, Mr. Welch, do you understand that a contempt of court for failure to pay child support can carry up to 45 days in jail on a first offense and 90 on a second?
Yes, ma'am.
And you understand it's a crime not to pay your child support as ordered?
Yes, ma'am.
Okay, are you currently employed?
No, ma'am. Actually, I do want to say I am going to pay it all up front, and I'm sorry that I actually brought it to this point, but I haven't seen my daughter in 4 years, and I have a
She don't care, buddy. She does not care. This is not the hearing for that. This is only about you. I know you don't want to hear it, but legit, all about you not paying. Yeah.
I have a warrant, or I have a court order here that shows that my ex-wife was supposed to.
So I'm going to tell you something.
Yeah,
Here's the
okay.
deal. This is child support. This is visitation. They're two entirely separate things.
I know, I've tried to hire 2 lawyers now.
Two
and none-
entirely separate things. So whether or not you're exercising or getting your visitation is something you got to go through the court system for. You start out at front of the court,
I did.
you know, and then you come up to a referee, and then you come up here to me. Child support is entirely different.
I know, and I actually set these up just so that I could actually get to this point.
Okay,
Because
so do
nobody's-
you have the money to pay your?
Yes, today.
Okay, so we don't take checks, is that correct, Ms. Pelham or Ms. Stevenson?
That's correct. It would have to be cash.
I have cash.
You have cash, so and it's $1,905?
I have a lot more.
Okay, so if you want to go down and pay your arrearage, bring the receipt back up,
Okay.
okay?
Right there. Thank you, ma'am.
You're welcome, and then just bring me the receipt. In the matter of Lauren Phillips versus Robert Phillips, file number 2020-47595 DM. Says date and time, set for a show cause. Mr. Phillips is not in the courtroom, I don't believe. Mr. Phillips is ordered to pay $483 a month in child support. He has an arrearage of $3,217.50. Last payment we received was $223.68 back on October 3rd of 23. So, Miss Adams, could you call Mr. Raines on this? This is a Raines file. He might be down in Judge Savers.
Okay.
So I'm going to pass that one. In the matter of Erica Prock versus Todd Prock, file number 23-50931 DM. It doesn't look like I have Todd Prock in the courtroom. Mr. Prock was ordered to appear. Looks like he's supposed to pay $751 a month in child support. As of today's date, his arrearage is $6,438.39. The last payment we had was $50 on April 16th of 24. He did not appear on April 8th, and a bench warrant was issued. He came into the front of the court, paid $50 to get rid of the bench warrant. He said he would be in to pay again and never did. All right, so I'm going to issue a bench warrant for his arrest. Failure to appear, and I'm going to set bond in the amount of $1,500. Did you hear from, or anybody from Mr. Rains? Great, that concludes our friend clerk show cause docket, other than, Mr. Welch going down and paying, so he should be down there soon.
Oh,
Mr.
you're just
Philo?
gonna wait?
Are you Mr. Philo? Why don't you come up to the podium? This is file number 24-2617. It's PHILO. 2617, Judge? Yeah, there's no code.
Okay.
All right, so this is in file number 24-2617. You're James Allen Philo. So Mr. Philo, on weekends, I get a cup of coffee and I check the jail list, and I noticed you were on the jail list for a jury contempt. So I called the jail and I had them release you, and thank you for showing up. Yep, thank you for showing up this morning. So what I want you to do is go down to the clerk's office, okay? And it's at the end of the hall on the left. They're gonna give you a questionnaire. You can fill it out right there and hand it in, and then this will all be taken care of, okay?
Okay, cool.
All right.
I don't get paid until Thursday, so I can start taking care of it then.
I don't need you to pay anything. You don't owe me anything. It was $100 bond. I'm not worried about that. Okay, I'll quash that. So you just go down there and fill out the paperwork, okay?
Clerk.
Yep, just walk straight down the hall, and right across from the elevator is an office. I'm gonna call her and let her know you're on your way, okay?
Thank you.
All right, thank you.
They jailed him for not going to jury duty? What the fuck? Also, I love that the judge drinks coffee and looks at the jail list on the weekends, like as a pastime. Like, oh yeah, every weekend I make myself a strong cup of coffee, and I look at the clusterfuck of people that have gotten themselves arrested and think of what my next week holds. You almost missed it. We're not quite done yet. We're waiting on a gentleman to see if he arrives back. He said he had all the money. He said, that $1,900, I got it. I got it, Judge. I got it right now. And she said, okay, go pay it. So that's what we're waiting for at the moment. And then that dude just came out of nowhere. That was weird. Seriously, again, jailing somebody for not going to jury duty is crazy. Did he say I don't get paid till the 32nd, by the way? That's funny. Oh, that's funny. Oh, I'm not saying that it's not possible, and I didn't know that. I just, again, I watch a lot of the US justice system. It's pretty bogged down. Find it interesting. Oh, hit play.
This is Anne Marie. Mr. Philo was picked up this weekend, and he's on his way down, and he was worried about paying, and I told him I'd flush him the bench. Yeah, he's gonna come down and fill that out for you right now. Yeah, he's on his way to you right now. All right, bye. All right, Mr. Rain, sorry about that. We have Mr. Let me see, who are you on? You're on Mr. Phillips, correct?
I am, Your Honor. I'm also here for Jacqueline Cebulski or Clegg. There was a
Yes.
Yep.
So on that matter, I always start these right at 8 o'clock, and it was an adjournment because income withholding is in place and money is coming out, and then I guess his income tax return. So Miss Iddings took care of that. So that got adjourned to, let me find it here, June 24 at 8 a.m.
All right, so we did have an income tax intercept that was applied to the arrearage?
We think we do, but if it isn't, he was ordered to pay it. If he hasn't filed his taxes yet. So I ordered him to, if there's not an intercept, to pay that directly to the front of the court. And then Ms. Iddings advised him to get a second job.
Okay. Okay, all right. Very good. Thank you, Judge. I was over before Judge Olsaver this morning, so my apologies for
No,
that.
I know. So then this is Phillips. So this is in the matter of Lauren Heidi Marie Farrar versus Robert Lee Phillips, file number 20-47595 DM. There's Mr. Phillips. All right, so Mr. Raines, this is a failure to pay. Mr. Phillips is ordered to pay $483 a month. As of right now, he has a rearage of $3,217.50. Last payment we received was $223.68 on October 3rd of 2023. And last time we were here, your client entered a plea of not guilty, and we adjourned it to today. So, Mr. Raines.
Your Honor, yes, I had last appeared before you on this matter and requested a short adjournment. As I understood, there may be some issues to further investigate. My understanding, and I think Ms. Stevenson is present, she's been working with my office fairly closely on this, is that my client had requested a 3-year review of child support back in September of 2022. Pursuant to that request, there was a front of the court recommendation to lower child support down to the amount of $345, which would have been, and that's the key phrase, would have been effective September 1, 2022. The other party did file a timely objection on October 17, but I believe, and perhaps Ms. Simpson can confirm, that that recommendation somehow was not located by the front of the court until very recently. At any event, the filing of that objection had prevented the entry of a new USCO, which would have lowered the amount of child support to $345. The parties became embroiled in other matters pertaining to parenting time, and there have been referee hearings and, in fact, hearings before Your Honor regarding parenting time, but the issue of child support was not addressed. I have in my possession a copy of a mediation report authored by Mr. Godfrey that does make reference to the this child support history, as I've mentioned, and also what purports to be an agreement that was reached between the parties to be that reduced amount of $345. But unfortunately, we never had a hearing on the objection that was filed by Ms. Farrar. So, Your Honor, by my math, if he were to be entitled to that reduction, that would be over a period of approximately 19 months, and that would reduce his support arrearage by over $2,600, which would leave him somewhere perhaps in the $800 range of an existing arrearage. My client is self-employed. He's beginning some new self-employment work here very shortly, and what I would like, Your Honor, is I was hopeful, frankly, that I would have a hearing date set up with the friend of the court on this issue of the objection filed in 2022 by Mrs. Farrar, but I have not done that yet because we're just really trying to figure out what the procedural history is. So, Judge, given all of that, if Your Honor would be agreeable to another mediation to allow us to see if we could have a friend of the court hearing to address support and address this arrearage issue. It's not going to be a retroactive modification because the objection has been pending now for a year and a half. But if we could have some time in order to get that noticed up, participate in a hearing, that may resolve a substantial amount of this arrearage.
All right. Imagine if your client had made those payments even based on that a lower amount, he would have been very close to have no arrearage. So at the very least, he needs to make payments, and if he gets an income tax return, he needs to apply that to the arrearage as well. And I'm of course willing to do that, but are you talking mediation with Godfrey or someone else?
Well, they had participated in mediation with Godfrey. This predated my representation of Mr. Phillips, and it appeared to be from the written report that he generated, there appeared to be an agreement that he would be paying at this reduced amount, but that was never turned into a court order. So I don't know, based on the nature of relations between the parties today, if the other party would be agreeable at this point to a consent order that would adopt that dating back to September 1 and effectively resolve the support issue. But I can explore that with her counsel.
All right, so, all right, very good. I'll adjourn this to June 24 at 8 a.m. Mr. Phillips, you could have been at least making the minimum payment the last year or so, and then you wouldn't be in this predicament. So I suggest you start making the minimum plus a little extra, get this arrearage paid down, and meet with your attorney to try to do that agreement to get the arrearage reduced. And then we'll see you back on June 24th at 8 a.m. All right, thank you, Mr. Raines.
Thank you, Your Honor.
Thank you. Mr. Welch, you want to come on up?
All right, we're about to see, did he come back? Did he make the payment? Before we get to see that, I want to remind you guys, I have set the stream up to auto redirect over to Tech Troublemaker, who is doing a live special tonight featuring Mikey from Credence and Mikey, friend of the channel. I want us to go over there, even though it doesn't start for another hour. After this done, please go over there when it redirects. Leave a comment in the live chat. Leave a like. Let's make it a very successful live for them. And I will be watching later on. Always a good time over there. So, do we think he has a receipt for the full payment? He owed $1,900. Let's see what happened. Let's see.
And Ms. Stevenson, Mr. Welch came and paid off the arrearage owed.
Okay, Your Honor, I will make record.
I'm sorry?
Okay, I will go ahead and note that.
No, she's
asking. Did he? I'm asking you.
Oh, I'm sorry. I thought he brought a receipt up. I can go check.
Yep, he's got his receipts. I just was gonna make sure. All right, so Mr. Welch, I'm going to dismiss this. And it gets confusing to people because they are intertwined, but child support and parenting time are two separate things. And if you had the money to pay this arrearage, you probably have that money to hire an attorney to do a referee hearing.
I have actually hired 2 attorneys and neither one of them have gotten back to me. This
Well,
happened during.
hold on. So if you paid them and they didn't do any work, then that's something, but you don't hire them until you pay them. So I would suggest that you just hire someone local or whatever, pay them and have them do a referee.
Yeah, I had put money into an account that they actually requested me. So it put $1,500 into an account for Matt Raines, and I had emailed him back and forth, and after my second email, I'd never received anything back.
Okay, well, I would now talk to their office, but the route you need to go for that. And like I said, it's completely separate from child support. So go ahead and proceed that way, all right? But your monthly amount is $336, so make sure you make that monthly amount, all right? All right, thank you, Mr. Welch. That concludes our friend of the court show.
Thank you.
Thank you. I have a Randy Long, but I don't know what he's for. Might be early first.
You got one more for us, Judge? One more.
Mr. Long, I have someone who's logged in as Randy Long. What is your name, please? Have someone name the screen name of Randy?
Yeah, I'm Randy
Long.
Long, right here.
Hi, what are you here for?
I was here because I had contempt of court for you. I missed a court hearing back last year. I didn't get the Zoom meeting ID number mailed to me in time, and I tried calling your secretary, but I was
So
unable.
hold on a second. What's the other party's name?
Catherine Crew.
All right, Miss Adams, I don't show him
I'm
anywhere in my
looking.
doc. Yep, hold on, we're gonna look it up, okay?
Yes, ma'am.
And they left us hanging. I'll have to do some research onto that and see if I can figure out what happened to him. He looks scared. Guys, I appreciate you so much. I know there's lots of good court to be watching right now. As a reminder, redirect over to Tech Troublemaker. Make sure you sub to that channel and leave a like down there and a comment. Tell them, you know how we love to razz our family. Looking all gangsta. Oh, earlier it was even worse. MB, watch this. Oh, my hair is so long. It's hard to be gangsta. It's hard to be a gangsta. There. That's less gangsta. Flip the hat backwards. I don't know if that will look, but I think, like, what's up, bro? I just want you to remember like 3 things, okay? You gotta remember, I love you. I'm proud of you. See you in the next video.